Good evening. This is the September 27th, 2010 Austin Constitution meetup. I'm your discussion leader, John Rowland. Tonight we're going to be discussing the problem of how we discern the original meaning or understanding, or whatever you might choose to call it, of the founders when they wrote the Constitution. This issue comes up again all the time in legal discussions. The progressives often take the position that although it might be nice to know what the founders originally meant or understood, that there's no way to do that. First, they're not available to us to interrogate, to let us know when we get it wrong. And second, there were a lot of them. And we have to expect that different founders would have different meanings, different understandings, different intentions. And who is to say that the meaning, the understanding, the intention of one founder should be preferred to the others? This, of course, brings us into the general realm of how is it that we can understand anyone, especially if they are not available to question. It is very easy to say, well, because we can't know what the original meaning or understanding was, we are unbound to any obligation to that original meaning and understanding, and we are free to give it whatever meaning we want. And they may say, well, you can't really accuse us of wanting to do anything we please, because there are words that are written here on paper, and even if they don't mean the same thing to us today that they meant to the people who wrote them, they do mean something to us today, and you shouldn't complain if we interpret them according to our meanings, if we were using them, if we were writing them today. The problem with that approach soon becomes clear. The Constitution, like many of our laws, has been on the books for a long time. The Constitution for now over 230 years. Consider, for example, what would we do if we were trying to apply a law, state law, against murder, and someone were to say, well, that law was written 200 years ago. We're not bound to the meaning of murder. And, oh, by the way, I'm going to prosecute this guy who murdered the English language. He used it ungrammatically, he used it vulgarly, had a lot of grammatical errors. So we're going to consider that to be murder. We're going to prosecute him for it. And if we get a conviction, we'll execute him. Now, I'm sure many of those of you out there who have misused the English language once in a while would not want to be prosecuted for murder because somebody thought you murdered the English language. And yet, if we are unbound to the original meaning of murder, who is to say that we can't use it to mean misusing the English language? Similarly, let's say, for example, that an umpire at a sports event miscalls a move in the game, and the losing side, its fans, rise up and yell, "We was robbed." Well, can you prosecute the umpire for robbery? Throw him in prison? Is that what the word robbery means? Well, maybe it does to some people using it today, but if we start applying words written many years ago by persons no longer alive, to which we are in some sense bound to obey, then don't we have to try to find the meanings that those words had to the people who wrote them? Bringing it closer to the language of the Constitution, we have such words in the Constitution as jury. Well, it doesn't say in the Constitution how a jury is supposed to be impaneled. What would be wrong with modern people today saying, well, you're entitled to a jury, but the Constitution doesn't say how a jury is supposed to be selected, so I'll tell you what we're going to do. We are going to gather up a pool of public employees, and particularly those that are have as their principal job executing people convicted of death. And we are going to charge you now. Remember, we're charging with murdering the English language. And we're going to give you a panel of jurors. We'll make it 12. You know, the Constitution doesn't say it has to be 12, but hey, well, we're traditionalists. So we'll give you a jury of 12 executioners. And oh, by the way, they get paid for each execution they do. So, and some of them may in fact be executing you if you get convicted. And you say, well, wait a minute, wait here, that's not fair. I'm supposed to be tried by a jury of my peers, not a jury of people who have a stake in deciding against me. And the prosecutor might say, well, wait a minute. The Constitution doesn't define what the jury is. Doesn't even use the word peers. Where does it say that we have to pick a jury that's neutral? You say, well, that's implied. Jury is supposed to be neutral. It's not supposed to be paid for killing me. And I said, well, no matter how you pick the jury, it's being paid, and if they decide to convict you, they're being paid to kill you. So, well, wait a minute. They'll be paid regardless of how they decide. Well, who says that? We can't pay them more if they convict than if they acquit. Here's the deal. We'll pay them $10,000 each to serve on the jury if they convict, and if they acquit, they don't get anything. Isn't that fair? He says, no, it's not. Well, hey, where in the Constitution do you see anything that forbids us from doing that way? He says, well, but wait a minute. The founders meant something when they used the word jury. Surely we need to follow what their meaning was. And they say, well, we're all progressives here. But we don't agree with that. We're free to use whatever meaning we want to give to these words. And if you don't like it, well, you just have to win an election and gain the positions of power like we have, and then you can interpret it your way. But elections have consequences, Your side lost the last election, and that's just the way it is. Well, wait a minute. I didn't vote for this. Well, you voted for some candidates, didn't you? Yeah. And aren't those candidates letting us do what we're doing now? Yeah, but I didn't consent to having them do this. Says, well, are you saying that they defrauded you, that they misrepresented what they would do if they got elected? Well, no, I can't really say that. They never really brought it up at all. Well, if they never brought it up and you voted for them, then how can you complain? I mean, yeah, I mean, you voted for the people who are now in office. There are enough people in office that if we all decided to amend the Constitution, we could. We've got enough votes, enough officials, enough in the state legislatures and Congress, and we could all decide just to amend the Constitution to make it murder to misuse the English language and make it a proper jury to consist of only public employees paid to render guilty verdicts. So, you elected us. Says, but you haven't adopted an amendment like that yet. Well, but we could. You know that. And you voted for us. So you kind of voted for our ability to amend the Constitution. And if we don't actually amend the Constitution, well, details. So, by this time, you should be beginning to get some idea of the problem involved in allowing the present generation of public officials to interpret statutes any way they want, or to interpret constitutions any way they want, or judicial decisions, or even their own decisions, or the decisions of their predecessors. If we allow officials to give words any meaning that they want, then we have a situation like that described in George Orwell's 1984, in which the party, represented by the character O'Brien, could redefine the words of the language from one day to the next. They called it newspeak. And newspeak is a word in the English language that we use to refer to this practice. Do we want to consider the Constitution as written in newspeak? Is that really what we want? Some people might want that. Some people act as though it were true. So, we have a party too, just like Orwell's. Maybe not quite as determined to cause suffering. Remember the end, O'Brien explained that the way to demonstrate that one has power is to cause suffering. That it's not enough for people to merely do as they're told. You don't really know that they're doing as they're told for the right reasons unless they're also suffering. So, as O'Brien explained, the purpose of the party, its mission, its destiny, its whole reason for being, was to cause endless suffering to the end of time, to put a boot in the face of the people for all time, and never let up. Now, you may say, well, wait a minute, where's all this going? Obviously, I'm not in favor of this kind of lawlessness. And, well, progressives will say, well, how can you call it lawlessness? It's our law. We're in charge. You elected us. We're we're the judges. The law is whatever the judges say it is. And you might say, well, wait a minute. I don't think the law is whatever judges say it is. Judges can be wrong. They can be corrupt. They can be biased. Just because a judge makes a decision in a certain way doesn't make it right. Then you say, okay, maybe not. But unless and until you elect a different set of officials who will appoint a different set of judges, you're kind of stuck with it, aren't you? So this is the dilemma we all face. What do we do today with a government, which is essentially a bunch of individuals, a bunch of officials, who are determined to do what they want without much regard to what the Constitution originally meant? Now, let's move away from this for a moment and suggest that, okay, we do really want to try to find out what the founders originally meant. What was their understanding of the words of the Constitution? Now, we can recognize when we do this that we aren't necessarily looking for agreement. We're looking for agreement on the meanings of the words, but not necessarily on which words should have been chosen. So we can have founders who, deeply disagreed about whether these words or those words should have been in the Constitution. Maybe they had wanted other words entirely. But they did finally settle on a few words, and we have to figure out, did everybody consent to those words being the words of the Constitution, and did they all understand them in the same way? Now, the obvious answer is they probably didn't all understand them exactly the same way. Whenever you are making a decision in concert with others, you really are starting initially with an agreement to abide by the decision of the group, which may be by a majority vote or maybe a supermajority vote, but you start with an agreement to agree, and then you agree on something. And that something may not be satisfactory to everyone, but they initially agree to go along with it. They might not agree not to try to change it later. They may continue to work on doing that, but at least for the time being, they go along with it. So, what is it that they were at least agreeing to go along with? We have to understand the process involved. We need to look at the records that we have of the development of the Constitution and the Bill of Rights. Because really, the Constitution was not completed on September 17th, 1787, or when it was ratified on June 21st, 1788. It got amended. 10 amendments were adopted based upon calls for amendments, about 200 of them, by the 13 ratifying states. A lot of those calls were duplicated. Several states simply adopted copies of lists of amendments already approved by other ratifying conventions. But we can certainly see a pattern. A lot of those amendments were structural. They wanted to change the structure of government or procedures of government. They wanted to change which officials, but a large number of them were properly recognitions of rights. In other words, general restrictions on the powers of government. It is those amendments that James Madison felt that he was obliged by his commitment to the original anti-federalists who agreed to go along with ratification if the amendments were made, if a Bill of Rights were adopted. So he felt, and the others felt, that they need to honor that obligation and to adopt what came to be called Bill of Rights. So they extracted those proposed amendments that recognized rights, and it started out with about 19 of them, and they started boiling them down. They tried trying to make them as concise as possible. And generally, they picked out the ones that were the most sought after, the most controversial, the ones that it was thought that if not adopted, opened the way to the greatest potential abuse. But to make sure that the listing of certain rights would not be interpreted to mean that the list was exhaustive, that the government had the authority to violate the rights not listed, they added a Ninth Amendment, which simply lumped together all the unenumerated rights which hadn't been listed in the first amendments, and said that these are rights too. Now, what does that mean to us trying to interpret them? We have an amendment to the Constitution, part of that law of the land, which says that not all rights are in the Constitution, at least not explicitly listed. So what are we supposed to do with those? How do we find unenumerated rights? Well, the answer is that we have to go to the legal history. We can start with the rights that were demanded by the state ratifying conventions. And then we can go into the legal scholars of the time. We can look at just Blackstone and Edward Cook. We can look at the Declaration of Independence, which cited a lot of rights that have been violated, and most of those rights were not made explicit in the Constitution, but we can reasonably presume that all of them were to be included in the Ninth Amendment if they weren't included somewhere else. Such as, for example, even the slogan, "No taxation without representation." It doesn't say in the Constitution that you have to be represented before you can be taxed, but that was certainly an understanding of the revolutionary generation, and one can certainly assert that it is in the Ninth Amendment. So, we are having to look beyond the words of the Constitution. From the very beginning, in 1791, when the first 10 amendments were adopted, including the Ninth Amendment. So it is telling us, in no uncertain terms, that in order to interpret the Constitution, we have to look to legal history. And it is not an answer to a legal argument in court a right is not listed in the Constitution, therefore the person doesn't have it. One is expected to look to history. Now, what does it mean to look to history? Well, to understand that, we have to look at what the founders did when they drafted the Constitution. They started out not with words, but with ideas. They had certain ideas about what they wanted the Constitution to contain, what they wanted it to do, what results they wanted to achieve with the words that they were about to adopt. So the ideas started first. And ideas are another word for meanings. People can have ideas, meanings, before they have words for them. Most words started out as ideas, and the words were adopted afterwards. Sometimes people borrowed words that are already being used for other purposes and used them for the new ideas. Sometimes this worked well enough, the word acquired a new meaning, and in that context, the word now had that meaning. But these were legal words. The Constitution was not written in ordinary English. It was not even written in ordinary legal English of 2010. It was written in the legal English of 1787. And guess what? The legal English of 1787 is not the legal English of 2010. The language has changed. In fact, one could argue that in 2010, most legal words don't have fixed meanings either, even for most lawyers and most judges. They're constantly arguing about what words mean. Congress or state legislature adopts some new act, and immediately the lawyers and the judges start, tearing into it to try to figure out what it means. Our Speaker of the House said that we had to pass a health care bill to find out what was in it. Now, that's a very interesting comment about which much derision has been cast, but it does illustrate part of the problem. Very often, Congress adopts legislation without any member of it having read it all. They're just trusting their staff to do the job right, so it won't embarrass them afterwards. Well, sometimes it embarrasses them afterwards anyway. I have worked with congressional staff, and they are not particularly bright. They are mostly not our best and brightest minds. And so, very often they have agendas of their own. So what a congressman asks the staff to put into the bill may not be what actually winds up getting in the bill. It may be something entirely different, and the member never notices it. So, when you look at the way legislation is actually drafted, I think most people would be shocked. But why should we imagine that the drafting and ratifying of a constitution would be any different? Actually, by today's standards, the work done by the Constitutional Convention was very, very good. In fact, if you look at the efforts to write state constitutions before and since, and the constitutions of other nations, The Constitution of the United States, written by those delegates, is amazingly good work. Considering that that work was done in 1787 and has had 200 years of being argued over, you would think that people writing constitutions, whether they be for states or for other nations, today would do it better. They don't. Many of the constitutions for nations and states, well, we haven't had one for a state since the Alaska Constitution, but we do have amendments to state constitutions. The draftsmanship evidenced by most of those efforts is really pretty poor. And when we see some of the proposals for amendments to the U.S. Constitution that are being proposed in Congress all the time, they are mostly poorly written political statements. They're intended to be easily understood, but to cause a huge amount of trouble if they ever got adopted. Fortunately, they almost never do get adopted. A lot of people have the idea that the Constitution is just too hard to amend, that the founders made it too hard to amend, that it's not worth the time and effort to try to propose and get ratified amendments to the Constitution. Well, this is wrong. It is actually not that difficult to get amendments to the U.S. Constitution. A single individual revived one of the first 12 proposed amendments, one of the two that was not ratified in 1789, and he got it ratified as a 27th Amendment. Basically, most of the work to do that was done by a single self-financed individual. Now, the reason why he was able to do that is, aside from the fact that it had a pretty good pedigree, having been proposed all the way at the beginning, is simply that it was a pretty good amendment. It was well drafted. And what most of the amendments that have been proposed since then have in common is they're very poorly drafted. In fact, if you look at the amendments that have been adopted by to the Constitution, it seems like all the talent for drafting amendments to the Constitution ended with James Madison. Because starting with the 11th Amendment and almost every amendment thereafter have been poorly written. And that is a very dismal situation. You would think that talented people would still be among us, that they would have the ability to draft proper amendments. But we don't find that. So if you want to know why it's so difficult to get amendments adopted to the Constitution, it's not because the process is so difficult. It's because so few people know how to draft one that's any good. And if somebody ever did, you might find it's not that difficult at all. Assuming, of course, that those in power were prepared to accept a well-written amendment. Because, of course, many amendments needed, and I have drafted a number of them, which you can find at constitution.org, would not want to support those amendments because they would have an adverse effect on their own power. They would conflict with what are sometimes called reliance interests. We have a huge body of government officials and special interests who have come to rely on the legal order as it has come to be. And they don't want to change it, even in ways that most of them could agree are good ideas. Simply tooling up to deal with a new amendment could be very expensive, and they'd rather not have to do that. So, we are confronted with several problems. First of all, to get back to the original concept, original question of this the topic of this meeting this evening, is how do we understand what the founders meant and under what they understood? I've said before, that they started out with meanings, with ideas, and then they tried to find words with which to express them. Now, where did they find those words? Well, a lot of them were lawyers, and they found the words in their own legal backgrounds. They had some benefit of the various states, 13 states, adopting their own constitution, state constitutions, after declaring independence from Britain. One of them just kept using the same constitution it already had, but by and large they adopted new constitutions. So they had a period of time between about roughly 1776 and 1787 or beyond, 1788, when they were experimenting with different state constitutions, learning the language, learning to understand the concepts, hammering them out, and generally using the state governments, the state constitutions, as incubators for the insights and the language that they would then need and use in drafting the Constitution of the United States. However, that experience didn't provide all the language they would need. They still had a lot of concepts, a lot of ideas, a lot of meanings that were not embodied in the state constitutions that they wanted to convey in the new national constitution, or federal constitution, as some would prefer to say. So, when they went to draft the language of the federal constitution, they looked for a language that would serve their purpose. They found some of it in their own legal backgrounds, but those legal backgrounds were not always enough, because a lot of what they were trying to do was to prevent abuses or mistakes, or whatever you would choose to call them, that had emerged in England that had not emerged in the 13 states of British North America. So the states, the newly independent states, were not acquiring experience in some of the tyrannical things that were going on in Britain. But the Americans were very cognizant of what was going on across the Atlantic, and they said, well, if it's happening there, it could come over here. So we need to adopt a constitution that will prevent some of the bad things that happen in England from happening here. And since we don't have direct personal experience here with a lot of those things, we're going to have to look to English authors, English scholars of law, for guidance on how to do that. Well, they had several. The two leading ones were William Blackstone and Edward Cook. Blackstone had written his commentaries on the laws of England. And although by today's legal standards they were not very as scholarly as we would like, Blackstone was, as a commentator, was, let us say, not the best scholar. But he did write his commentaries as four books, 4 volumes, which it was feasible to print copies and spread them and buy them and read them. So they became fairly popular. Edward Cook wrote earlier than Blackstone. He was mainly writing for English lawyers, and although his were also a kind of collection of commentaries, they were also a kind of codification of the principles of law, which had developed over the course of several centuries. They were not as easily understood. There was a lot more to read. There were not very many copies in the new U.S. states. Madison and Jefferson had their copies, but they weren't available in every law library. So, although Jefferson, Madison, and the others preferred Cook over Blackstone, they were at a disadvantage in trying to refer to them. And when they did refer to them, they were also often doing so in just talking to people who did not have their own copies. So, during the Constitutional Convention, some of the members decided that they wanted to adopt a constitutional provision which forbade making criminal laws that were retroactive. They thought it was profoundly unfair to make it a crime to have done something that was not a crime at the time it was committed. They were trying to think in terms of writing statutes to define crimes and not just to rely upon the common law, the criminal common law, which was the basis for much criminal prosecution in England. So, they had a problem. How would they express the notion that Congress, and for that matter, the states, were not to adopt laws that were criminal laws that were retroactive? And some of them came up with the idea, let's forbid ex post facto laws. But then one of the members of the convention said, "Oh, wait a minute. Are ex post facto laws only about criminal laws, or do they also include civil laws? For example, would they make it illegal to adopt a tax retroactively? Maybe maybe Congress would meet in March, and he wants to adopt a tax law that's retroactive to January 1st, the beginning of the year, which would make it a lot easier for accounting, and other purposes. You're not declaring anybody delinquent for not having paid a tax on January 1st. You probably are only going to charge him at the end of the year, not at the beginning of the year. So it might affect his planning a little bit, but it's not going to make it an offense not to have paid the tax for the period before the statute was passed, because you're not actually collecting it retroactively. You're collecting it for a retroactive period. So this delegate named Dickinson looked up the phrase ex post facto in Blackstone. Evidently he didn't know Blackstone well enough to know it off the top of his head. And in Blackstone he found that it referred to ex post facto laws as only criminal. Now, that's interesting because even though most of the members of the Constitutional Convention were lawyers and had presumably read Blackstone and knew the word ex post facto, apparently none of them knew off the top of his head whether the phrase only applied to criminal laws or could apply to any kind. So they had to look it up in a copy of Blackstone they had with them. And once they could all look at it, see it in print, they could agree, right, the phrase ex post facto conveys the meaning that we want, so we'll adopt it. And they adopted, without much further discussion, the provisions that for Congress in the Article 1, Section 9, and for the states in Article 1, Section 10, that they were forbidden from adopting ex post facto laws. So, here was a clear case, which Madison documented in his notes on the Federal Convention, where the idea was introduced. There was a discussion about what words to choose. Some words were proposed. There was debate on whether the words meant what the meaning was that they were trying to convey. And when it was thought that they did, the words were adopted. However, are these the only meanings that the words had? Could the words not also have other meanings in the works of the legal authorities, Blackstone, Cook, and others? And if they did not those words carry the meanings from those earlier writers? Because you see, when the founders referred to authorities that they respected, what they were really doing were buying in, were affirming the meanings of those authorities, even if they didn't always know what the meanings were. If it was later pointed out to them that Blackstone or Cook or one of the other legal authorities that they respected had also meant something else by the words they adopted, they would almost and certainly have said, okay, we adopted those words, and now we discover they have these other meanings, so it has those other meanings. Because the authorities we respect had those other meanings for those words. So this is what we mean when we talk about doing the historical background investigation to find out what the words of the Constitution meant. It means going back and looking at instances of usage of those words had in the sources that the founders respected, that they considered authoritative. Now, what were those sources? Were they dictionaries with definitions, the way we might try to do today? No. Generally speaking, the founders did not use dictionaries. Such things did exist. The first ones had been developed. Dr. Samuel Johnson had published his Dictionary of the English Language, and the Encyclopedia Britannica, the first edition, had already come into print with its articles which discussed the words in it. However, Johnson's dictionary was too expensive. As far as I know, none of the founders had a copy. I don't know whether they had copies of the Encyclopedia Britannica. We don't find any reference to it in their discussions. So if, and of course, we can question whether if they had had copies of those books, they would have considered them authoritative. It is most likely that they would not, at least not beyond a certain point. Most scholars, especially legal scholars of that time, did not respect dictionaries. They thought that it was impossible to capture the meanings of legal terms in short definitions. At most, they could use lexicons, which are sort of like dictionaries, which was used with students, including law students, to serve as a kind of primer, as the beginning text for the discovery of the real meanings, but not to be used as authoritative in themselves. So it's sort of like we might use a thesaurus today. A thesaurus which can list synonyms or antonyms to words, but which does not really provide much in the way of an authoritative background on those words, but leaves it to the reader to conduct his own investigation. And what the founders would almost all have said, being lawyers, is that to understand these words, you have to go back to instances of their use, which is mostly in cases. Sometimes it is in commentaries, but in any case, you have to look at the words as they were actually used, and sometimes you have to read between the lines to figure out what they meant. Because in almost no case were the words defined. They were simply used, and you had to read the whole long document in which they appeared in order to get a sense of their meaning. That's why you will not in general find a lot of quotes from the legal literature of that era. You won't, for example, find a lot of pithy quotes from Blackstone or Cook, because they rambled, or at least by today's standards, they rambled. They would go on and on and on and on, discussing legal concepts, and without ever actually trying to boil them down into a few short words. Now, the need for a few short words was certainly felt. Judges, lawyers, commentators did try to come up with legal maxims. We have legal maxims going back to ancient Roman law, in which somebody would try to summarize some legal principle in just a few words, usually very few words. But maxims could carry a lot of authority. They were often regarded as authoritative, but they were basically just slogans. In carrying a lot of meaning, you had to go back to the original cases and commentaries and discussions, discourses, which gave rise to those maxims. You couldn't just rely on the words of the maxims themselves to carry all the meaning. And at Constitution.org, we have collections of some of those maxims. They're very interesting, very instructive, but they are not to be relied upon as complete expressions of the principles they represent. They are only beginnings of a process of discovery. So what we have in the works of the founders is a learning process. It started with ideas. They tried to find words. They found words. They discussed whether they were the right words. They may not always have agreed, but in most cases they had to choose some words, so they chose the best ones they could find. In many cases, those words had additional meanings, a legacy of meaning that one would have to go back into history to find. But the founders must be held responsible for the words that they chose. And we do need to figure out from the historical background what they meant or tried to mean. But in many cases, we're going to be left still having to guess to some degree. Now, what do we do when the words they chose are a little bit ambiguous? Well, in that kind of situation, we do have what are called the common law rules of construction, some of which are expressed in those maxims I mentioned. For example, if the words are about the delegation of a power, the common law rule of construction is that powers are to be interpreted strictly. The obverse of that are powers, or rights. That means that rights are to be interpreted broadly. Judges and lawyers today who try to do just the opposite, to interpret powers broadly and rights narrowly, are getting it wrong, mostly getting it wrong. The rule is that if there's any doubt about whether a government official has a power, the conclusion has to be that he does not. If it's unclear whether he has a power, then it must be held that he does not. And there's still some power that he needs that he doesn't have, then you're going to have to adopt a new delegation of authority, of power, to cover that. And since rights are the obverse of powers, they're the complement of powers, they're what's left over after powers are delegated, then the implication is that if powers are to be interpreted strictly, then rights are to be interpreted broadly. And there are two kinds broadly, of rights which come into play here. The first are the rights which arise out of nature, society, and the state, which pre-exist the Constitution. Rights that we can consider fundamental. The second kind are the rights which arise out of the fact that there have been no powers delegated. The omission of a power establishes a right. The power could have been delegated, and if it was, that would restrict the right. But if it was not delegated, then the right remains as a non-delegation of a power. Now that is not necessarily a fundamental right. It could just be the failure to delegate a power. But it is still a right that has to be recognized, because the rule is that if an official does not have a power delegated to him, then he doesn't have it and may not exercise it. And by the way, part of the problem that moderns have with interpreting delegations of power is that they think that a delegation of a power is a delegation of authority to do whatever it may take to get a certain result, a certain outcome. And that is not what delegations of powers meant. A delegation of a power in that era meant the authority to make a certain kind of effort, not the authority to do anything they might want to get a certain result. If you as an official try to exercise a delegated power and you have a certain purpose in mind in doing that, you may not do whatever you think it may take to accomplish that purpose. The authority you have is only to make a certain kind of effort, and if that effort is not enough, you're stuck. At the point where you have made the effort and it still doesn't get the desired result, you may not proceed further, not without further authority. If you as a well driller have been authorized to drill a well 100 feet deep, and you reach 100 feet, and you still haven't found water or whatever you're looking for, you are not authorized by that original delegation of authority to keep drilling. You've got to stop. And if you think that there may still be water down there, if you drill a little further, you've got to go back to your customer and say, okay, I've drilled 100 feet, we didn't find water, but I think if I drill another 20 feet, I might find some. Do I have your authority to drill another 20 feet? And then, and only then, if the customer gives him authority to drill another 20 feet, may he proceed to do that. And if after drilling 20 feet, he still hasn't found water, he has to stop. Maybe he can get authority to drill another 20 feet, and another 20 feet, and another, until he finds water. But he has to keep going back to the source, to the customer, for additional authority. He may not proceed further without it. That's the way we have to think about the powers in the Constitution. So, that brings us to an interesting area, which is the subject of a blog post at constitutionalism.blogspot.com of whether or not criminal common law was incorporated into the Constitution. The non-conflicting parts of the common law were, but the question arose whether that included common law crimes. At the time the Constitution was adopted, ordinary crimes like murder and robbery and fraud and perjury and a lot of others were unwritten. They were understood to be offenses which could be punished, usually as felonies, which carried the death penalty, but there was no actual statutes on the books defining them to be crimes. All that lawyers and judges and courts had to go by were court precedents. There was a legacy of prosecuting people for these crimes, of convicting them, of sentencing them to a penalty, as I said, often death, carrying out the penalty, and all without a statute. Now, the alleged authority for that was the notion that crimes were offenses against the king, the crown, as it were. When a prosecutor went to court prosecuting some crime, he was said to represent the crown. Well, now, since the 13 states declared independence, there was no crown. There was still a sovereign. The ancient principle was that there is no law without a sovereign, but the king was not that sovereign. The people had replaced the king as the sovereign. And the people's will was expressed in doing things like adopting constitutions and electing legislators to pass statutes. So without a monarch, without a king, the will of the people could only be expressed through legislators, which meant that laws had to be adopted as statutes. However, the states, many of them, had adopted common law crimes and continued to prosecute them without adopting statutes making them crimes. Evidently, there were some at the Constitutional Convention who thought that might continue at the federal level with Congress. Evidently, there were others who didn't think so at all, or who didn't think about it at all. So, we have Congress adopting a few things as crimes, defining powers of Congress to make them crimes: treason, counterfeiting, piracy and felonies on the high seas, and offenses against the laws of nations were the ones that were listed. They did not include murder, or robbery, or fraud, or perjury, or any of those other common law crimes. So, did Congress have the authority to pass statutes making those things a crime? And they proceeded in 1798 to adopt criminal statutes against what we call the Alien and Sedition Acts. And many, including Thomas Jefferson and James Madison, protested very strongly that there was no authority to make it a crime, in the case of the Sedition Acts, to criticize a government official. And in fact, under the Sedition Acts, a number of people were prosecuted. They were thrown in jail, even though there had been adopted a First Amendment forbidding Congress to infringe on the right to speak and the right of the press. So, Thomas Jefferson arranged to have the new state of Kentucky adopt a set of resolutions called the Kentucky Resolutions of 1798, in which they flat out said that Congress has authority only to make crimes of treason, counterfeiting, piracy, and felonies on the high seas, and offenses against the laws of nations, and nothing else. And that did not include sedition. In Virginia, Madison had the Virginia legislature adopt similar, although less specific, resolutions. A year later, Kentucky adopted a somewhat reworded but set of resolutions, the Kentucky Resolutions of 1799. And a year after that, Madison issued a report to the Virginia legislature, which was adopted as its position statement, which said very similar things. So, almost immediately, we had a conflict over whether or not Congress had authority to make all sorts of things crimes. They had adopted a statute early on, the very first Congress, making it a crime to rob the mails, for example. So, did Congress have any authority to do any of that? Well, when Thomas Jefferson was elected president in 1800, and during his and the next two presidents, James Madison and James Monroe, no such further legislation was permitted. In 1812, during the Madison's administration, a case came before the U.S. Supreme Court, United States versus Hudson, in which the court concluded, in a rather sparse opinion, that Congress did not have the authority to make anything a crime except those few things that were listed. It said that common law crimes were not authorized under the Constitution. It did make one exception for contumacy, the crime of refusing to obey a court order. It held that that was a necessary implied power of the judicial power, but that was the only exception, that no other crimes, common law crimes, could be prosecuted under statutes that Congress could adopt. So that pretty well shot down things like the Alien and Sedition Acts and even the statute making it a crime to rob the mails, although that wasn't adjudicated in that case. So, where did that leave if federal officials if they wanted to prosecute a crime for which Congress did not have the authority? Well, the answer is that they would have to prosecute it under state law. Or, for those territories that were under the exclusive legislative jurisdiction of Congress, perhaps they could do it there. The District of Columbia, for example, or the Western Territories, but not on state territory. So, they had a problem, however, that yes, they could charge someone under state law, and then it was considered perfectly okay for a federal official to come into state court as a prosecutor. But they ran into trouble if the state statute didn't quite define as a crime the thing that the federal officials might want to prosecute as a crime. So they felt a need to be able to define these offenses as federal crimes, to be prosecuted in federal courts with federal judges and under federal rules. They didn't have that situation for a long time. It was a continuing source of tension. But it does help us understand the state of law until about 1886, when Congress adopted the Interstate Commerce Act and defined the very first criminal offense as under the Interstate Commerce Act clause, and opened the door eventually to interpreting the Commerce Clause to imply criminal powers. But that will remain a discussion for another meetup.